Hi, this is David Black, Law Offices of David A. Black. Today is Friday, June 8th, 2012. The discussion of the day, a question that friends of mine and people unfamiliar with the criminal law often ask me, is what can and can't I be pulled over for? I'm driving on the road, what are my rights? The first thing I like to tell people is that they should understand that there are limited rights on the roadway. Because the roadway is a public place, courts have held that police have an extra duty of community protection, and likewise, I guess conversely, drivers have a limited right to be free from searches and seizures. Now, that does not mean that you can be pulled over for no reason. It doesn't mean that you could be pulled over for what's called just a hunch in the case law. What it means is that a case that made legal the Terry Frisk, which is Terry v. Ohio, and involved officers suspecting a robbery was taking place, simply asking for information, stopping somebody temporarily, and frisking them, patting them down, has been applied to drivers on the roadway. And the specific terminology is if the officer has specific and articulable, reasonable suspicion based upon facts, specific and articulable facts which rise to the level of reasonable suspicion, then that officer can temporarily detain that individual. Now, reasonable suspicion is lower than probable cause, but nevertheless it requires some finding that there is something that is not normal, something that not every driver is doing, and something that causes this officer to reasonably believe that this person is committing a crime or traffic infraction. That means that if you're weaving within your lane badly, potentially the officer has suspicion of DUI. Now, there's no other traffic violation that's weaving within your lane, so he couldn't suspect that. And in fact, that's an issue that we're litigating presently, and we do litigate a lot. If you fail to maintain a single lane, the officer has a reasonable suspicion, at least one specific fact, to think that you violated the unsafe lane change or failure to maintain a single lane statutes. People often say that we commit 1 million traffic violations every time we're on the road, and an officer simply has to pick one of them. That's true, and it's not true. One of the things that we look for are the time of day and the officer's detail to see if he's actually using these reasons, these minor traffic infractions, as a pretext. A case named Wren says that it's okay to have a pretext. You're allowed to pull over a drug smuggler because he's a drug smuggler, as long as he also commits some other traffic violation. But the pretext can call into question the accuracy of his observations. Did he really commit a traffic violation, or was the officer making that up? And that's what we try to do in these cases where somebody is on a DUI task force and our client is pulled over for something minor. Now, if the real suspicion is DUI, that's fine. Just like in Wren, it's fine. But it does call into question whether or not that infraction actually occurred, or was he just leaving the parking lot of a bar, like another case we're handling right now. Anyway, it's a complex area of law. It's something we love to look into in every single case, and certainly something that a good criminal lawyer, whether it's me or somebody else, can flesh out for you and see if your case can be won that way. And certainly we have won quite a number of cases arguing a lack of reasonable suspicion. If you have any questions, as always, feel free to call us, and I appreciate you watching our video blog today.